employers sometimes compartmentalize conditions or an illness. They don't really realize that I'm so focused on dealing with a workers' compensation claim, I'm not recognizing it as potentially an FMLA leave. So think of it this way, if you are dealing with a workers' compensation claim, and by virtue of my workers' compensation condition, my on-the-job condition, I'm missing work, that is going to be subject to FMLA. If you're covered by FMLA and I'm eligible for FMLA. Anytime I have a workers' compensation condition that incapacitates me for work and I miss work, by definition, that's also going to be an FMLA condition. Second example, let's say I suffer from or exhibit an ADA disability, a medical or health condition that rises the level of disability under the Americans with Disabilities Act, and I miss work. Again, you've got a situation in which I'm experiencing a medical condition or health condition which is incapacitating for me. That means, guess what? That's an FMLA leave issue also. Now, here's where it gets a little bit dicier. What about a workers' compensation condition? Is a workers' compensation condition always an ADA disability? What do you all think?
No, I think you still have those minor, injuries. Somebody hurts their ankle, pulls a tendon, that sort of thing. It's funny, you do go to some ADA seminars where they're like, everyone's disabled now. I've got some clients who don't even bother to even go through the analysis of disability anymore. They're just like, well, I'm just going to assume everybody's disabled, give them all a scooter in their own bathroom. I'm like, it's going to be a very expensive way to do business. And the law really, we're not to that point yet. A lot of people, kind of went overboard of the ADAAA and said, oh, everybody's disabled. But, in the workers' comp realm in particular, you can take a step back and don't just presume, and that's one thing we're going to talk about in the interactive process part, is, don't go down that road, before you have to. Anybody who just comes in and says, hey, I turned my ankle, you don't have to go buy them a scooter and, all of a sudden, offer them reasonable accommodations of years of leave and that sort of thing. So, but as you should point out in one of the earlier slides, because of the ADAAA, that chasm that we used to have between, disabilities, which are way up here, and everything else is up here, is now kind of here. There's still a chasm, but it's gotten a lot smaller than it used to be when that question was a lot easier.
Well, and I think the same thing is true when you're trying to decide whether my medical condition that triggered an FMLA leave, whether it rises to the level of the ADA disability. And that's why we put a question mark here. It's really a function of what kind of medical condition you're wrestling with, how severe is it, and what's the duration. If I've got a medical condition which is going to resolve itself and there's no residual limitations or restrictions, I broke my leg at work, it's a workers' compensation, but basically I'm going to miss work, so it's going to be a workers' compensation claim. I'm also going to probably be covered by FMLA because I'm incapacitated, but after I've finished that healing process, I'm not going to have any residual disabilities or restrictions. That's not going to rise to the level. You need to look really at each particular situation to see if it rises to that disability. So this is a little checklist, and I don't promise to be perfect. It's kind of my thought process to make sure I'm asking the right questions. We talked a little bit about at what stages in the employment process should you have your antenna up, should you be wary of whether you're dealing with an overlap. This is kind of how I think about it, and please jump in because I'm sure I missed some steps here. But, the first thing I ask a client when we're trying to kind of unravel an overlap or potential overlap is this a workers' compensation issue at all? Because each state tends to have very unique and specific provisions. So the first thing I want to get out of the way is, hey, is this an on-the-job injury? Because we're going to have a very different process. The next question I'm going to say is, does the FMLA apply to you as an employer? If you're under 50, don't worry about it. If you're 50 or over, then we need to run that trap. And if you're covered by the FMLA, is this employee eligible? Again, this isn't perfect. This is just kind of my checklist as I'm trying to work my way through a potential overlap.
And one thing, too, we did mention earlier about the 50-employee mark that a lot of employers that have gone through reductions over the past few years forget is that if you had 50 employees in the past calendar year for 20 work weeks, don't have to be consecutive, on your payroll, and again, remember we talked about temps are included in that number. But if you had, some kind of, right at that 50 mark, it's like, well, we just laid 3 people off, so we're at 47, so we don't have to give anybody leave. It's like, not so fast. Now, if that's your only facility, and there's not 50 employees within a 75-mile radius, then you wouldn't have any covered employees.
Right.
But just watch that as far as, because if you have a fluctuating workforce, because maybe you're seasonal, maybe you've had some recent layoffs or that sort of thing, watch it. That 50-employee threshold covers you for a 2-year period. So if you had 50 or more in 20 work weeks last year, calendar year, then this whole calendar year you're going to still be a covered employer. So just kind of watch that, because some people jump off the bandwagon too fast, and it's like, you are still covered. So
we've asked the question, is it workers' comp? We've figured out whether FMLA applies to you and whether that individual is actually eligible. Next question is, let's assume that FMLA applies. Does this employee suffer from a serious health condition under the FMLA that's defined, and we're going to talk about today? My next question is, has this employee, let's assume you're covered by the FMLA, they're eligible, they suffer from a serious health condition, have they exhausted their 12 weeks of the FMLA, or do they have some remaining rights that they've not yet exhausted? Then I go to my ADA checklist. Is this a disability under the ADA? And we're going to, again, talk about what a disability means, particularly under the regulations, the new regulations and the new amendments. Does it prevent me from performing essential functions of my job? And do I have an obligation to consider reasonable accommodation?